What's going on, everybody? Welcome to the Ryan Pineda Show, where we talk all things money, real estate, and entrepreneurship. And for today's episode, I am going to be explaining the question that I probably get more than any, and that is, how do I fill out a real estate contract? All right, so in this video, I am going to cover everything, line by line, what it means, how to fill it out, so that there are no more questions about this. But before we do that, do me a big favor, make sure you go and hit the like button so this video can get more exposure and more people can understand how to do this. Now, a couple of things before we jump into the contract. Number one, you actually need a contract, right? We need to be looking at the same exact contract. So we're gonna use the same exact contract that I use, and I'm going to give it to you guys completely for free. All you have to do is go to futureflipper.com. It's in the link below. You can download it. It's a very simple contract, and that is what we are going to be using in this demonstration. So I'll give you a second to download it before we go over this video. Did you do it? The other thing to know is different states are going to require different types of contracts. This contract will work in most states, but some may require you to tweak it a little bit. That's why I'm giving you the Word document so that you can change it. So what I would say is, if your state title company or attorney does not allow you to use this contract, ask them what part they want changed, and then you can easily change it. And if you caught what I just mentioned, I said title companies or attorneys. In the states I invest in, like Nevada, California, Arizona, we are a title company and escrow state. Everything is done at the title company. But some states like New York, where I've bought at, everything was done through an attorney. The process is almost the exact same, but just know that different states function in different ways, and they talk a little bit different lingo, but it means the same thing. Okay, so let's go through the contract line by line so that you guys know exactly what I'm talking about. Okay, so when you go to my website, I'm gonna give you 3 different contracts. The first one is the Residential Real Estate Purchase and Sale Agreement. The second one is the addendum to that agreement, and the third one is the assignment agreement. So the residential real estate purchase agreement is the first contract that you need to get signed by you and the seller. The addendum to that is if you guys make any changes down the road to the contract. And the assignment agreement is if you are going to wholesale the deal to someone else. It all makes sense as we go through this video. So let's jump into the most important one, which is the real estate residential purchase and sale agreement. A lot of people commonly just call this the RPA, Residential Purchase Agreement. So if you see me refer to it like that, that's why. Okay, so as you guys can see, there is 4 pages to this agreement. Some of you might only need 3, and I'll get to that when we get to the last page, but this is the purchase and sale agreement. So let's go through it line by line. This purchase and sale agreement is entered by and between blank, the seller, so you're gonna put the seller's name there, and blank, the buyer. So that's where you're gonna put your name or your LLC. A lot of people ask me, do you need an LLC? You don't. Eventually you should if you start doing deals, but starting out you don't. Buyer and seller shall jointly be referred to as the parties, which is legal. A lot of this, by the way, guys, is legal jargon as well, so I might gloss over it because it doesn't really mean a ton. Description of the property. So this is where you're gonna put the address, where you're gonna put the city, state, and zip. The APN is the parcel number. You guys might have it called something else in your state, so that could be adjusted. Property is sold in as-is condition. Obviously, most of the stuff we buy is as-is condition. That's why we're getting a good deal. We have it bold and big so that the seller knows that we are buying it as is, and it makes them feel better. Property includes all fixtures, windows, and floor coverings, built-in appliances, draperies, hardware, shades, blinds, I'm not gonna read the rest of it. Basically, it's saying anything left in the home becomes ours when we buy it. And we always tell our sellers, you can leave whatever you want, just know that it becomes ours. Next thing, the purchase price. The seller shall convey the property to the buyer for the sum of blank. So right here, you're going to write the purchase price in letters. So if it's 200,000, you're gonna spell it out, 200,000. And then right here, you're gonna write it numerically. So you're gonna just put it 200,000 in numbers. Seller acknowledges this price may not represent fair market value for the property. We are telling them that we are getting a deal on this. We don't do this for free. We're trying to make money. Closing costs and taxes. Okay, so for us, we always say we're gonna pay them all, but we leave it blank here just in case you guys negotiate it differently. So all closing cost title fees are to be paid by. Typically for us, it's gonna be the buyer, but sometimes you might be able to work it so the seller pays them. Transfer taxes to be paid by. You're gonna choose buyer or seller. We always pay it. Property tax, sewer, trash, HOA fees, SIDS, lids, or other assessments will be prorated at the close of escrow. Seller shall pay all liens recorded against the property at the close of escrow. So this means anything that the seller owes as far as taxes, trash, sewer, all this stuff, it gets prorated, which means to the day of close. So let's say we close in the middle of the month, March 15th, whatever. They are going to pay taxes and all of those things up to March 15th only. So if they owe a bunch of money, they're gonna have to pay all that current. That's their responsibility. It gets taken out of their net. Maybe they prepaid their taxes. Sometimes we see that with sellers. So maybe they've paid it all the way to July. Well, they're actually gonna get a credit from March 15th to July, and they'll get that money back. Proration just means that you're gonna pay it only to that date. So assuming everything looks good on the first page, if you guys are in agreement, buyer, which is you, are going to initial here. I only have one signing block because it's usually just me or my company. And then the seller, we have two signing blocks. So if it's a husband and a wife or whatever the case is, if there are more than two sellers, you could simply just add a line here. Okay, next part, page 2, the due diligence. Buyer shall have a period of blank calendar days from the date that this agreement is fully signed to complete its due diligence. Seller shall ensure that the buyer's representatives have reasonable access to the property during this period. Seller to disclose any conditions that adversely affect the property value. Okay, let's start with that first part, okay? This is your period to get your inspections, to go see if you have a buyer, if you're trying to wholesale it. Typically, we will put anywhere from 7 to 14 days. If I already know I'm gonna buy it, sometimes I'll just put 0 days because I know for a fact I've got a home run deal. I don't need to do any inspections. But for you, put at least 10 days so that you have time to figure out if you're gonna do this deal or not. Okay, second half of that. Anytime before the due diligence period expires, buyer may terminate this agreement by written notice of cancellation to the seller and escrow company. Escrow company shall refund the earnest money deposit to the buyer without the seller's consent if within the due diligence period. Basically, this is saying we can back out during the due diligence period and get our earnest money deposit back. Earnest money is at the bottom of this, so we'll talk a little bit about that in a second, but just know that you can back out during the due diligence. All right, part 5 of this, escrow. Title and escrow company shall be the buyer's choice. So you guys can pick wherever it is. It's your choice. Close of escrow shall be on or before blank. So you're gonna pick the date of close. Typically, we always do 30 days out. We can close before that if we want. It's on or before that date. Section 6, this is what we were just talking about with the earnest money deposit. Within 5 business days after this agreement has been signed by the buyer or seller, buyer shall partially perform by delivering an earnest money deposit of blank to escrow for the benefit of the seller. So within 5 days of getting this signed, you need to put your earnest money deposit down with the title company. This amount can be whatever you guys agree to. I've said it could be as low as $10. I've seen $100, $500, $1,000. I've done $5,000. $10,000, it can be anything, but make sure you have enough to actually put down. The bigger the earnest money deposit you put down, the more you're at risk of losing the money. So make sure if you are gonna put a significant amount down that you're for sure gonna buy the property. As you can see here, the earnest money shall be non-refundable to buyer unless buyer is unable to insure title to the property. So maybe the title company's not willing to insure it because there could be a lot of reasons why they wouldn't insure it. Seller is unable to deliver clear title to the buyer. This is part of the reason why they wouldn't insure it because they can't guarantee clear title. They kind of mean the same thing. Seller fails to execute all documents necessary to timely close escrow on the sale of the property. So maybe the seller becomes uncooperative and won't sign paperwork. That happens sometimes. Or buyer issues timely notice of cancellation under section 4 above. So we canceled during the due diligence period. Those are the only ways we would get our earnest money deposit back. If the seller's uncooperative, if we can't get clear title, or if we canceled during due diligence. If any of those don't apply, you can lose your earnest money deposit. So remember that. This provision shall be construed as consent by the seller and an instruction to escrow to return the earnest money deposit to the buyer in the event of the conditions listed in the preceding paragraph. So basically it's saying if any of those apply, we get the earnest money deposit back. All right, section 7, tenants. If one or more tenants occupy the property, then any rental income will be prorated at the close of escrow. So same thing as the taxes and insurance from before. You get it prorated. So you would get rent from, say, March 15th all the way to March 31st if they've already paid a full month. Seller shall provide all leases to the buyer before close of escrow. That's self-explanatory. You should have the lease. Seller to provide all security deposits, cleaning deposits, keys, and other tenant deposits to the buyer before the close of escrow. So make sure if you're buying a property with tenants that you get all those deposits because now you're responsible for giving it back to the tenant when you get them out of there or whatever happens. If everything looks good, you guys would initial down here again. All right, so this is the last page of the RPA. Additional terms. This is where you guys would write anything else that you agree upon. A very common one that we do is a seller rent back. So maybe the seller says, hey, I'm willing to do your deal, but I need to rent back for 2 weeks after the close of escrow. So that means you're gonna buy it. They still have 2 weeks in the property to get their stuff moved and get on to their next place. So we would write that in here, that seller to rent back for 2 weeks after the close of escrow. But a lot of times what we'll do in that situation is we will make the title company hold money back. We'll say title company to hold back $5,000. $5,000 to be released to the seller upon vacating within 2 weeks. So if they don't vacate within 2 weeks, that $5,000 now legally should go to us. Does it always happen that way? No. Anytime there's money in escrow, there's usually a fight for it. So any additional terms will be in this section that you guys come up with. All right, here's some miscellaneous stuff. Neither buyer nor seller are represented by a licensed real estate agent. No commissions are due or payable in connection with this transaction. I don't care if you are a licensed agent or if the seller's a licensed agent, there's no brokerages involved in this deal. It's just buyer and seller. We're making that very clear. Buyer may assign its rights under this agreement. So that means that you have the ability to assign the contract to someone else and make a wholesale fee. Seller is aware that buyer is purchasing the property to make a profit and may or may not market the property for sale or lease, including on the MLS. So this gives us the ability to go and market the property for sale even though we don't own it. And legally, we could do it on the MLS in our state if we so choose. We don't do it often because sellers might get really mad about it, but we have the legal right to do it. Make sure you check your state's local laws if you're able to actually utilize this clause. 4, in the event of a dispute concerning the interpretation or the enforcement of this agreement, the prevailing party shall recover reasonable attorney's fees and costs. So if there's a dispute, it's going to the attorneys. That's nothing new. 5, this offer expires at 9 p.m. Pacific Standard Time on blank. So this would just be the date that you put this offer expires. A lot of times we do this to put pressure and to show scarcity that, hey, this offer doesn't last forever. You're gonna do this or not? And then boom, if everyone agrees, both the sellers would sign here, you as the buyer would sign here, you guys would date it. This is it for the RPA. That's it, it's just simple 3 pages, covers everyone's parties. Everything is very much defined, and this is the exact same contract that I personally use right now. This last page is optional. I'm not saying that you guys need to use it. This is the disclosure and confirmation of no agency relationship. So you're gonna put the property address here, and essentially, I'm not gonna read all of that. Essentially, this is just saying that no realtors are involved in this. Once again, I don't represent the seller doesn't represent me. I am not looking out for the seller's best interest. You definitely want to use this if you're a realtor. You want to be very clear with the seller. I don't represent you. I don't even represent me. I'm just a buyer trying to buy your home. There is no realtors involved. And the reason I had this form made was because I own a real estate brokerage, and I want to be very clear that we do not represent them. We are investors trying to buy a deal. You don't have to do this one, but get it done if you want. All right, now let's go on to the addendum agreement. Okay, so this page is super simple. This is the addendum to the residential purchase agreement. Right here, you're going to put addendum number. So if this is the first change you guys are making to the contract, it would be addendum number 1. But you can have contracts that have multiple addendums. So you could be on addendum 3, 4, 5, depending on how many changes you guys make throughout the process. Same deal, you're just gonna put the buyer, which is you, you're gonna put the seller, which is them, you're gonna put the date of the contract, and you're gonna put the real property located at that address. Now, this is where you're gonna put the amendment, okay? Maybe if you're doing a price reduction, you're gonna say the purchase price shall now be $100,000. Maybe before it was 110. This is a common addendum when you go and inspect it and you see that, oh man, it's in worse shape. I need a new price. Or maybe you're not ready to close on time, so you need to change the close of escrow date. There's a lot of things that you can use this addendum for, but anytime you're making a change to the original contract, use this addendum. All you have to do is just have both sellers sign. On this one, we just have 3 seller blocks just because we had room for it. You may need it. Then you put your buyer signature right there. Let's go on to the assignment agreement. Okay, so the assignment is strictly only if you are going to wholesale it to someone else. If you're gonna buy it yourself, you don't need this. Now, here's how the assignment agreement works. You are going to find the buyer, and maybe you know that the buyer is willing to pay 20 grand more than what you have it under contract for. So your assignment fee is gonna be 20 grand. So let's just use this as an example as we go through it. But the assignor is going to be you. You, the buyer, are assigning it to the assignee. The assignee is the person who is going to be the end buyer. Now, you're gonna put the total purchase price. So you're not gonna put your wholesale fee. Let's just say that you have the property under contract for $100,000 and you know your buyer is gonna buy it for $120,000. So in this section, you're going to put $120,000 and you're gonna spell it out in letters. Then right here, you're gonna put it numerically, $120,000. The undersigned assigner does hereby assign to the assignee all the rights everything to the property located at blank. So you're gonna put the address. Now, your assignee needs to have an earnest money deposit. Remember, when you put your earnest money deposit down, they need to put one down. Typically, we always ask for $5,000 non-refundable so that we know that the assignee is ready to buy this property. So typically right here, you'll put $5,000 as an earnest money deposit. If the earnest money deposit is not received by blank, so you're gonna put the expiration date. Let's say you're doing it tomorrow. You must deposit $5,000 by tomorrow. Then this agreement is void. So this prevents anyone from tying it up but not taking action. They need to put their earnest money deposit by a certain date and time. Assignee close of escrow date is on blank. So for me, I always like to set our close of escrow date before the RPA's close of escrow date. Because if they don't close by that date, I still want to be able to close for the seller and have a backup buyer, or maybe I buy it. I don't want to have those two dates be the same, because if there's a problem, they don't close, then we're screwed. We might lose our earnest money deposit on the RPA. So that's why we put this date supersedes the close of escrow date on the residential purchase agreement, so that they need to close by that date. It doesn't matter what the RPA says. This is the date they must close by. Assignee shall pay all escrow fees. I'm not gonna read the whole thing, but they're pretty much paying all the fees now. You're not paying it anymore. Then the assignee default clause. If assignee does not fund on the assignee close of escrow date, the assignment of the residential purchase and sale agreement is void. So if they don't close it on the date they were supposed to, it is void now. Escrow company shall immediately release the earnest money deposit to the assignor. So that $5,000 they put down, if they don't close by the date that they were supposed to, it comes to me as the assignor. Assignee shall be liable for all damages caused by the assignor. Theoretically, I could sue them for any damages as well. Here's the only way that they can get out of it. This clause shall apply unless the assignee is unable to ensure title to the property, seller is unable to deliver clear title to the assignee, seller fails to execute all documents necessary to a timely close of escrow on the sale of the property. So same things with the RPA. If the seller doesn't want to sell, that's not the assignee's fault. If we can't get clear title, it's not the assignee's fault. Okay, last part of this, if assignee does not fund the assigned close of escrow date, the assignment of the residential purchase and sale agreement is void. So if you don't close on the date that we put right up there on the assignee close of escrow, the contract is now void. And as this states, the escrow company shall immediately release earnest money deposit to the assignor. In the event of concerning the interpretation or enforcement of this agreement, the prevailing party shall recover attorneys. And then the last part just simply states that if there's any drama, it's gonna go through attorneys. As long as you both agree, just sign there at the bottom, and that is all the assignment is. So that pretty much covers everything with all of our contracts. We like to make them super simple but very transparent, so the sellers have no fear whether we're trying to pull one over on them or if there's hidden language. It's all super simple. And it's also simple because it makes it easier for you to explain to them what's going on. My whole philosophy has always been try and be as transparent as possible. It makes doing deals so much easier. Even if you're gonna make a lot of money, be transparent about it. I have found that sellers are much more likely to do a deal with you, even if you're making a ton of money, as long as you're transparent. Like I said, these are the exact same contracts that we are using right now. So there should be no reason you cannot lock up your very first deal today. So if you guys got great value out of this video, do me a big favor. Make sure you go and hit that like button. If you haven't already, hit the subscribe button, the little bell notification so you get updated every time I release a video. And as always, make sure you follow me on all the socials. And another big thing is, if you want to learn more about real estate investing and you want to be coached by me, I'm taking on new students, and all you have to do is go apply at futureflipper.com. My membership director will get in touch with you on a call, talk over all the different aspects of it, and see if you're a good fit. So get out there and get your first deal, guys. I appreciate you for watching. Take care.